Hello there, I'm Black Bright News, and I recorded this video on one of my other platforms by mistake. So I wanted to share what happens when you're on duty and you decide to do a good deed, and it could cost your life. You could cost your job. So I've called it "The Law Says Yes, Your Job Says No." And this is one of those stories that looks simple until you sit with it. A bus driver witnesses a passenger being robbed. He chases the thief, recovers the stolen necklace, and when the thief returns, there is a physical confrontation. The thief is knocked out. Police investigate and conclude that the driver used reasonable force. No criminal charges, and yet the driver is dismissed from his job. So, at ground level, many people read this and see a man who did what most of us hope someone would do if we were the victim. He didn't ignore the situation, he didn't turn away, he acted quickly, decisively, and in a way that appeared to protect the passenger. The police conclusion matters here. In the eyes of the law, this was not an assault, it was judged through the lens of self-defense and defense of another, assessed in real time, not with the benefit of calm hindsight. UK law allows for that. It recognises that people in threatening situations do not have the luxury of perfect judgment. They are allowed to act on what they honestly believe is necessary, so long as the force used is proportionate to that belief. That is why the police stepped away. But the moment you move from the criminal law into employment rules, the ground shifts. Employers are not deciding whether something is legal. They are deciding whether it is acceptable conduct for someone wearing their uniform, working their shift, representing their organisation in public. These are not moral judgments in everyday sense, they are risk assessments. For a transport company, a driver is responsible for driving the vehicle safely, managing passengers, and avoiding escalation wherever possible. Physical confrontation is almost always written into policy as something to avoid, not because staff are expected to be passive in the face of harm, but because once violence enters the picture, outcomes become unpredictable. Someone could be seriously injured, a weapon could appear, a bystander could get hurt, the driver himself could be incapacitated, leaving a bus full of passengers without supervision. From that perspective, the employer is looking at what might have happened, not what just happened. The key detail in this case is that the stolen property had already been recovered. Once the necklace was back, the immediate offence was over. When the thief returned, the situation became about personal safety rather than property. And I can understand that, because can you imagine? You're the driver, you've seen a crime, you've rectified the crime by getting the woman's necklace back, and then after you've done that and you're getting ready to drive the bus, I assume, the thief comes back to challenge you. And now you have to protect yourself and you knock him unconscious, and because that happens, you lose your job. But there's more to it. It's not that straightforward, to be honest. That distinction matters enormously in employment situations. Even if the force is still lawful, an employer may argue that the duty at that point is to disengage and allow police to deal with it. Not because the worker did something criminal, but because the company has decided that further physical involvement crosses a line they cannot manage or insure against. So I'm not sure if they're saying that the first part was okay. It was okay to go and retrieve the necklace. But what wasn't okay was for him to try and defend himself when there was a further confrontation. In essence, when you're on duty, I guess what they're saying is you shouldn't really get involved in it at all. Call the police or let somebody else do it because you are the driver of that bus. That's what I think it's saying. But then there's a dispute about who struck first. In a police investigation, that question is about evidence thresholds. If the standard for prosecution isn't met, the case goes no further. In a workplace investigation, that same uncertainty can be fatal. Employers are not required to prove guilt beyond reasonable doubt. They make decisions on balance of probabilities, credibility and trust. If the accounts conflict, if CCTV is inconclusive, or if the company believes policy was breached, regardless of intent, dismissal can still follow. What unsettles people about this story is not confusion about the rules, it's the feeling that courage and consequence have become disconnected. The public tends to think in moral terms. Someone was wronged, someone intervened, the outcome favoured the victim. Institutions tend to think in liability terms. Was this foreseeable, controllable, defensible if something had badly gone wrong? Those ways of thinking rarely align neatly. This case also exposes how narrow the protection of the phrase reasonable force really is. It protects you from prosecution. It does not protect your job. It does not guarantee institutional support. It does not shield you from disciplinary action. Many people assume that if the police clear you, the matter is settled. The story shows that it often isn't. And once again, if you're on the job and you are working, you cannot be the hero. Really, that's what it's saying, unless being a hero is your job. But it seems to point to the second part of the incident, the part where the first part was sorted out. That was fine. He retrieved the necklace, came back, did his job and was getting ready to drive the bus. That was all fine. I think what the employer is saying, that when that thief came back, he should not have confronted him, or he should not have hit him, or I don't know. Anyway, let me get on with it, because you know me, once I start digressing, I lose time. So there is a deeper social tension here. We're living in a time where everyday workers are increasingly exposed to antisocial behaviour, theft and aggression, particularly in public-facing roles. At the same time, those same workers operate under tighter behavioural rules than ever before. They are told to de-escalate, disengage and preserve safety, often without meaningful backup in the moment. When someone steps outside that framework and acts on instinct, even successfully, the system struggles to know what to do with them. None of this means the driver was reckless. It also doesn't mean the employer was acting out of malice. It means the two systems involved are answering different questions. The law asks, was this force reasonable in the circumstances? The employer asks, is this how we expect our staff to behave while on duty, in uniform, under our responsibility? Those answers can diverge without either being dishonest. What makes this story linger is that it forces an uncomfortable reflection. We say we value people who step in, who look out for others, who don't walk past wrongdoing, but we also design workplaces that are intolerant of unpredictability and physical risk. When these values collide, it's usually the individual who absorbs the cost. So this is not just a story about a bus driver losing his job. It's about the fragile space between legality and livelihood. It is about how quickly praise can turn into procedural consequence. And it is about the reality that in modern public work, doing what feels right in the moment does not guarantee protection once the paperwork begins. That is the lesson sitting beneath this headline. The law may say you acted reasonably. Your employer may still decide that they cannot stand beside you. And in that gap, a person can go from being seen as a hero on the street to being unemployed by the end of the week. And he'll be asking himself, was it worth it? This broadcast explores the difference between criminal law standards and workplace conduct rules, focusing on reasonable force, proportionality and employment consequences. It is an explanatory in nature and does not offer legal advice. So, I don't know, I think this is a learning for all of us that, as usual, we're told we cannot help. We should not assist because the consequences don't back us. We just have to leave it and let those who are employed to deal with it, even though they're not around. That's what it tells me. And I don't know. But I guess what it's really saying is if you're at work and you're on duty, leave it to the people who are employed to deal with it. I think that is the lesson. Take care now. Bye bye.